Welcome, everybody. Welcome. Thank you for joining us this evening. As you are coming in tonight, please introduce yourself in the chat. Tell us who you are. Tell us where you're coming from in North Carolina tonight. And anything else you want to do to introduce yourself. As we know in North Carolina, it has been a slow news cycle over the last couple of days. So that's why there's 150 of us coming together on a Monday night. But as you are coming in, please take a moment, introduce yourself in the chat. Tell us who you are, where you're coming from, and maybe a little bit of why you are here tonight, even though we all know why we are here tonight. Thank you, friends. We're going to give it just a moment here so we can get live on Facebook and continue to welcome people in. Looks like we've got a lot of friends here. We got people from Hillsborough. We got people from Raleigh. We got friends from Democracy, North Carolina, from NC Campus Engagement, Pro-Choice NC, the NC Young People's Alliance. We have our friend Fair Election Center coming in all the way from DC. Welcome. President Deborah Maxwell from the North Carolina NAACP, Apex, North Carolina, Wilmington, America Votes. And I love that energy in there. Let's work, team. This is not a moment for defeat. And we are here tonight to talk about these cases and what comes next. It is very good to see all of you. As people are coming in, keep introducing yourself in the chat. And we are going to get started. A couple quick notes. We are in the webinar format today. You're going to hear from lots of different speakers. We have left a lot of time open at the end of this call for your questions. Our good friend Ann Webb from Common Cause North Carolina is going to be tracking your questions in the chat, but we encourage you to use the Q&A function at the bottom of your screen for questions that you have as this program goes on. And I promise you, we know that there are a lot of questions. I still have a lot of questions, which is why I'm great that our friends, the lawyers, are here to help us answer them. And we will make sure we get to all of those. So let's get started. First and foremost, good evening. Thank you for joining us on what was really short notice to be here tonight in situations that were forced on us by the North Carolina Supreme Court. My name is Gino Nuzalillo. I use he, him pronouns, and I am the campaigns manager at Common Cause North Carolina. We are here for one purpose tonight, which is to update each of you on the decisions that were made by the North Carolina Supreme Court last Friday, April 28th, in Holmes v. Moore, in Harper v. Hall, and in CSI v. Moore. I see a lot of people on here who are voting rights organizers, are concerned citizens, residents of this great state. These three decisions will have a significant impact on the future of our democracy and the future of our daily lives. And so this is an important call for each of you to be on to learn about what happened and what comes next. Before we get started, your hosts tonight, Common Cause North Carolina, the Southern Coalition for Social Justice, and Forward Justice have a few group norms that we say when we start off these events. First, we are here to educate, but we're also here to listen. Please, again, share in the chat your name, your town, and what brought you here today. Second, we are nonpartisan organizations. This is a nonpartisan space and a place for nonpartisan solutions to the challenges we face. We know that our opposition, we know that folks out there want this to be a partisan battle, but we know that it is a moral question of what is right and what is wrong about our people here in North Carolina. Third, we are centering racial justice in an intersectional movement. We know, especially in these cases, that it is racist and oppressive policies that have caused many of the representation and resource inequities in this state over the past decades and throughout its history. And it is only this acknowledgement and a fusion movement that will help us map a future that we can believe in. Finally, we are all here tonight because of some pretty significant decisions from the state Supreme Court. And we know that it has been a long fight over the last decade that has brought us here, and that many of you, myself included, are exhausted, and with good reason. We've been leading voter registration efforts, monitoring local officials, educating our neighbors about what's on the ballot, registering new voters, and on and on. And we are in, and Friday underscores, an ongoing fight to protect our democracy and ensure that more people can vote in the elections ahead. So what we need is you now more than ever. This fight is not for just Democrats and Republicans. It is not just for the political insiders in Raleigh or on Jones Street. This is about a movement to put people over politics, and that is a fight for all of us. So with that being said, that is the grounding that we bring into today's call. And we are going to get right into it tonight. If you've been here before, you know, we usually like to introduce everybody and have a little lead up before we get into a little appetizer before the entree. But there's so much to cover tonight. There's so much that happened with these 3 cases that just got decided last week. So we are going to get right into it, my friends. First, we are going to talk about the case known as Holmes v. Moore, a case about photo voter ID in North Carolina. And to explain to us what happened on Friday and what might come next, I'm going to turn it over to our friend Jeff Loperfido with the Southern Coalition for Social Justice. Jeff, take it away.
Thank you, Gino, and thank you everybody for being here today to talk about these important cases. Again, my name is Jeff Loperfido from the Southern Coalition for Social Justice, lead attorney on the Holmes matter since its filing back in 2018. So, briefly, what happened? What's this case about? This is the state court litigation challenging the constitutionality of Senate Bill 824, the voter ID law that was passed in 2018. It is distinct from the federal challenge brought by our friends at Forward Justice and a separate constitutional amendment challenge that's pending in state court as well. But this was a case in the current moment that was keeping Senate Bill 824 from going into effect. And the decision last Friday ultimately removed that prohibition from implementation, lifted the injunction. And it did so in a number of ways that are particularly striking, as you can kind of see on the PowerPoint there. Restored the state's discriminatory voter ID law. Briefly, not to get into the weeds on what we proved at trial, but there was a lengthy trial, 3-week trial, in fact, that followed multiple years of litigation. And at the end of that trial, the majority of the judges that oversaw that trial found that this voter ID had a disparate impact on African American voters. They were less likely to possess the IDs that the legislators selected. They were more likely to face barriers when trying to obtain those IDs or trying to use some of the so-called fail-safe provisions. And the manner in which it was passed was extremely suspect, crammed through during the lame duck session. And evidence showed during the trial that both the purported Democratic sponsor didn't even know the bill, what was in the bill that he was sponsoring, and the concerns about the racial impact were essentially ignored during the legislative process by leadership in the House and Senate. So, despite all that, despite the voluminous record before the court, despite the Supreme Court finding in our favor in December, mere months ago, this newly formed court from January did a number of things. In addition to just putting the law back in place, they raised the bar for proving discriminatory intent. That means they abandoned nearly a 50-year precedent coming from the U.S. Supreme Court on how to assess these types of laws under Equal Protection Clause in North Carolina. And essentially, they heightened the bar that plaintiffs will have to prove in future cases. So pretty extreme departures on a number of procedural steps, pretty extreme departures on the merits as well. I don't know if is there a next slide here, Gino, or if not, I'll just.
Head to the next slide. There you go.
Yeah. So, what happens, the law, our injunction has been lifted. The law is going into effect. There's still some open questions about how that is going to work, because what normally happens in a case like this is the court sends it back down to the trial court if they found that the trial court made a mistake. And then the litigants in the trial court sort of work through what's called like a remedial process. And in that process, we would have determined how are we going to roll this thing out? What has happened to date that allows the state board to actually implement this type of stuff? What's the status of all the things that the state board was doing before the original injunction? And none of that happened here. What the Supreme Court did essentially on Friday is declare, the people of North Carolina, the state board of elections, the legislature, to figure it out. They didn't give any guidance. They didn't really set guidance on the timing. in terms of like when the order should go into effect. So it's sort of thrown us into a scenario where we need to kind of be thinking about all the worst case scenarios. We need to be thinking about the possibility that there be some new legislation sort of either delaying certain aspects of the law, speeding up other aspects, changing the law, adding additional restrictions. There are a lot of unknowns, but what we do know is that voter education is going to be key, and letting people know that this change is coming is key, and that folks have to continue to watch and be vigilant and be engaged in the process of county boards of elections rolling this out, state boards of elections rolling this out, because there's going to be rulemaking, there's going to be changes to registration forms, there's going to be new trainings happening for poll staff, there's going to be new education efforts that are supposed to be dictated by the state board going out to the individuals, and other systems that need to be changed, all in the lead up to what the state board has said on their webpage that they're shooting for 2023 for this to go into effect. So, we're in May, the primaries start a couple months from now, and a lot of things need to happen. And we know from House Bill 589, the monster voter suppression law that was passed in 2013, that even with a 2-year rollout, there were issues. Our plaintiffs were disenfranchised in 2016 when that law was temporarily in place for the primary. And we know that with a multi-year rollout, there was issues, and you can only imagine what's going to happen in this case with such a short, abbreviated time frame.
Thank
next
you,
slide.
Jeff.
Yep.
And I think that may be on our slides, Jeff. I appreciate
you
coming on and giving us the overview here. And there's a couple key points I just wanted to add to what you shared, that in this decision about voter ID that came down on Friday, it was authored by Justice Phil Berger Jr., whose father is Philip Berger Sr., the Senate President pro tempore of the North Carolina General Assembly, and a named defendant in this case when they reversed Holmes v. Moore. That this came upon a petition. I want to make sure I get the legal terms right, Jeff. A petition for rehearing, which is an extremely rare, typically only used to correct minor issues, and in this case used solely because of the partisan composition of the court changing. And I want to make that really clear for our audience. We are here on a decision that was made just a few months ago by a previous court, because there is now a new court that seemingly is acting in lockstep with the legislature and assisting the legislature in accomplishing a goal that at least goes back to 2013, if not sooner, and to accomplish a voter ID law that we know has discriminatory impact, and that given the cost of obtaining it, basically imposes a poll tax on disproportionately low-income voters, working people, rural folks, our trans and queer neighbors, and people of color, especially Black voters. So moving forward, Jeff, we know that the State Board of Elections has said they will try to implement this in 2023, but if the General Assembly is going to implement this law properly, they have to provide photo IDs to every North Carolinian lacking one, and do so free of charge and in a way that is easily accessible. Jeff, is there anything else that's coming next about voter ID in our elections that you want the crowd to know tonight?
No, I think that was a great summary. I mean, we're going to learn more as the state responds to this obligation, as I'm assuming the legislature is going to do something to address some of the portions of the law that are currently stale or have passed in time. So there will be an opportunity for engagement, for education, for advocacy, and at all levels, at the State House, at local county boards, even at local precincts. So it's really important that folks stay tuned and keep up to speed on the latest implementation efforts.
Thank you, Jeff. And that is part of what we are doing tonight, which is to talk to all of you about what may come next. Already great questions about voter ID that is coming through in the Q&A. We will make sure we get to this at the end of this event as well. So if you have a question that is open in the Q&A, Jeff will be sticking around with us. Do not worry. We also have our other friends here who can help to answer those questions. But next, I want to go to the next big case that was redecided on Friday. It is a case known as Harper v. Hall that deals with partisan gerrymandering in North Carolina. Hillary, will you tell us what happened in this case?
Thank you, Gino. My name is Hillary Klein. I'm senior counsel for voting rights with the Southern Coalition for Social Justice. I work with Jeff. We were privileged to represent Common Cause in the redistricting litigation. And before I start, I just want to say how tremendous it is to see over 200 participants from pretty much every corner of North Carolina. That's really heartening. I can also see another plaintiff in this case, representatives from another plaintiff, the League of Conservation Voters, is here tonight. And I want to shout out them and their hard work in this case as well. Really, this is a difficult time for North Carolina. I'm just really heartened that everyone showed up tonight, and thankful to Common Cause for convening this. So what happened in Harper v. Hall? For about a year, just over a year, and for one election, North Carolina voters enjoyed freedom from extreme partisan gerrymandering. But unfortunately, what we saw on Friday, that freedom has ended. The North Carolina Supreme Court, in an unprecedented decision on rehearing, and I'm going to talk about that a bit, reversed an earlier holding from February that outlawed extreme partisan gerrymandering in all of our voting maps. In essence, the decision on Friday has greenlit the North Carolina General Assembly to draw the most extreme partisan gerrymanders they can muster. And you'll have to excuse me, I have I'm taking this from home, so my daughter's going to join me. But I'd like to talk about the unprecedented nature of what happened, because this is what happened in Holmes. It was upon rehearing, and also in Harper, this was a decision upon rehearing. Rehearing is extremely rare. In the past 30 years, less than 1% of rehearings were granted. But as soon as this court, with its new composition in January of this year, took control, it granted rehearing in these two cases, in the voter ID case and in Harper. And generally, rehearing is for times when there is maybe a change in the facts on the ground or a law that was ignored. My apologies, everyone. But that was not the case here. Rehearing was based on a change in composition of the court, and that's squarely not permitted. I'm going to turn it over to my good colleague, Tyler Day, to talk about the holding and the dissent in that matter.
Thank you, Hillary. My name is Tyler Day. I'm the Policy and Civic Engagement Manager with Common Cause NC. And as Hillary said, this was a really unprecedented ruling. And I want to highlight a quote from Justice Anita Earls. Back in 2019, the U.S. Supreme Court Justice Elena Kagan wrote an acute, powerful dissent to the majority's opinion in Rucho v. Common Cause. In that case, the U.S. Supreme Court declined to do anything about partisan gerrymandering, despite acknowledging how woeful it is. Justice Kagan called Election Day, and I quote, the foundation of democratic governance, and said that partisan gerrymandering, quote, can make it meaningless. Likewise, this year, North Carolina Supreme Court Justice Anita Earls wrote a potent, passionate dissent to the majority in Harper v. Hall, and she said, and I quote, following decisions such as this, we must remember that though the path forward might seem long and unyielding, an injustice that is so glaring, so lawless, and such a betrayal to the democratic values upon which our Constitution is based will not stand forever. I dissent from this court's majority opinion and its shameful manipulation of fundamental principles of our democracy and the rule of law. I look forward to the day when commitment to the constitutional principles of free elections and equal protection of the laws are upheld and the abuses committed by the majority are recognized for what they are, permanently regulating them to the annals of this court's darkest moments. I have no doubt that day will come. So very, very powerful words, really countering the majority opinion there. And so you may be asking then, well, what comes next after this decision? According to comments made by North Carolina House Speaker Tim Moore, we can expect legislative leadership to produce voting maps sometime in the summer of this year. It is important to note that politicians in Raleigh could absolutely enact fair maps this summer if they wanted to. It is within their power. They do not have to gerrymander it as they have in prior redistricting cycles. In fact, I don't think that we've had a decade since the 90s in which there was not some litigation over our maps because of gerrymandering. But in the last redistricting cycle in 2021, North Carolinians overwhelmingly asked lawmakers not to gerrymander, so they don't have to. But thanks to this reckless decision, it is unlikely that partisan gerrymandering can be challenged in North Carolina again and anytime soon unless Congress or the North Carolina General Assembly acts to make partisan gerrymandering illegal, although other grounds for legal challenge still remain, including on the basis of racial gerrymandering. And I'm going to turn it back over to Gino now.
Thank you so much, Tyler, and to Hillary and to Jane. Hillary, you're getting a lot of love in the chat. We start very early here in our movement with our young activists. And so thank you, Hillary, and thanks for the guest appearance as well, Jane. I wanted to underscore that just like we will see voter ID implemented in North Carolina this year, we know that this summer, at any time, that we will see the state house, the state senate, and the congressional maps completely redrawn. And there was a great question in the chat that I just actually wanted to uplift here because I think it's a point worth making and point worth emphasizing about how extreme and radical of a departure this decision is. Our friend Jeff from Durham in the chat said that the state constitution is fairly explicit about new maps only being allowed following the decennial census. What this court has done has essentially said that the maps that were drawn in 2021, the remedial maps that came after the first ones were thrown out, were never properly established. And therefore, there is no violation that the legislature will commit when it goes, again, to redraw the maps from whole cloth. They are getting, essentially from the court, a complete carte blanche to do whatever they would like to do with these maps, free of the restraints of partisan gerrymandering being illegal in North Carolina. When we talk about this court being in lockstep with this legislature, that is a perfect example of what is happening and what Justice Earls is dissenting from in Harper v. Hall. So thank you for that great question, Jeff. Even though I don't have an uplifting answer or a good answer for it, that is what the court has done, and it is brazen. Now, there's one more case that fills out the trio of decisions that came on Friday. So let's talk about the third and final one, CSI v. Moore. And for that, I'm going to turn it to the unmatched Kat Robles from Forward Justice.
Hi, everyone. Thanks so much. I'm Kat Robles, Senior Voting Rights Counsel and Litigation Manager at Forward Justice. I'm going to talk a bit about sort of the, legal decision that was made here and then pass it over to our wonderful communications manager after that to talk about what we are doing next. As you all may remember who followed this case, it's CSI versus Moore. It is a case challenging North Carolina's felony disenfranchisement law. This was filed in November 2019, and Forward Justice, along with Arnold and Porter and Protect Democracy, filed this on behalf of 4 organizational plaintiffs. I know I saw North Carolina NAACP on here tonight, one of our wonderful plaintiffs. We also filed it with Community Success Initiative, Wash Away Unemployment and Justice Served, as well as several directly impacted individuals who were not able to vote because of being on probation, parole, or post-release supervision for a felony. Prior to our lawsuit, the law was that if you were on probation, parole, or post-release, you could not vote until you had completed that entire term. We had 2 victories in this case, one in 2020 on summary judgment, where the court ruled that it was unconstitutional to keep people on probation or parole solely because they owed money. because it's akin to a poll tax. It's saying that people who had the money to pay their fees could vote quicker than those who didn't have the money to pay their fees. We brought this case all the way to trial. The trial court, a 3-judge panel, ruled for us, holding that this law overall is unconstitutional. It's racially discriminatory in its intent and its effect. Unfortunately, this past week, the North Carolina Supreme Court reversed that in a 5-2 decision. They took away both of those rulings. They held that the law in general and the fact that it is keeping people from voting solely because of owing money, they ruled both of those things are constitutional. So we had 276 days of freedom where people who were on, felony supervision, meaning they were living in our community, they were paying taxes, they were some of our wonderful plaintiffs, they were able to vote as they should be able to. They are here working and living. They are the parents at your school. They had 276 days where they were able to vote. Unfortunately, that was stripped away on Friday in our decision. Like I said, it was a 5-2 decision. The North Carolina Supreme Court decided to strip away voting rights from North Carolinians. And importantly, that group of people is disproportionately Black. We're talking about, a population of 22% of the state, but 42% of people who are currently on supervision. They had their right to register and cast a ballot taken away. In dissent, Anita Earl said that the majority's decision in this case will one day be repudiated on 2 grounds. First, because it seeks to justify the denial of a basic human right to citizens and thereby perpetuates a vestige of slavery. And second, because the majority violates a basic tenet of appellate review by ignoring the facts found by the trial court and substituting its own. So we are understandably disappointed. This now means we are back to where we were before we started, which means that people who are on probation, parole, or post-release supervision, parole is essentially gone. So that's mainly people on probation, and post-release supervision cannot vote until they complete all terms of their supervision. That can include the payment of fines. It could include your supervision being extended for years because of being unable to pay fines. So that is where we're at now, but I'm going to send it to Brittany to uplift us with just all the amazing work, because when things don't go the way we want in legal, we have the best comms and organizing to bring out the other part of our campaign.
Thanks, Kat, for that amazing summary, and thanks for all of your work on this case. Over the years, this case started in 2019 before I was even on staff at Forward Justice. And so it's been a long, hard fight. And what you see on the screen now is a quote from Dennis Gaddy, one of our fearless leaders in this work, an organizational plaintiff in the case, the executive director of Community Success Initiative, one of the lead organizational plaintiff in the suit. And he talks about how Friday will be remembered as the day that democracy was gutted in North Carolina. I won't read it word for word, but he also talks about it showing the fear of accountability. And so one of the things that we are excited about is that we will be at the General Assembly. Oh, thank you, Gino. We could go back. This is a quote from one of our individual plaintiffs in the lawsuit. And Chiquita is amazing. And she, very valid question. If you're telling us we can no longer vote, are you also telling us that we don't have to pay taxes? Because to Kat's point, these are folks who are living in our communities. They're going to work, they're paying taxes, they're sending their kids to school, and they've now had their voices silenced. And so I think this is an important moment for us to be clear and not to back down. And that's why we will be at the General Assembly tomorrow. And we're inviting all of you to join us for our Second Chance Lobby Day. And we will be talking about this case, the implications of it. When you talk about stripping voting rights away from 56,000 people in any state, right, that's a hefty amount of folks that you're disenfranchising. But when you're in a state like North Carolina, where elections are regularly won by razor thin margins, right? When we look at the composition of the Supreme Court, Chief Justice Newby was elected in 2020, and he won by only 401 votes, right? And that's while this case was still tied up in litigation. And so it matters. This is a block of voters that should have never been silenced, and we're going to continue our work to make folks' voices heard. And so we hope that all of you will join us tomorrow at the General Assembly. Reverend Barber will be there. Dante Sharp will be there. Gino will be there. I am excited to see so many friends and faces that are on this call. We hope to see all of you there tomorrow, and we will continue to keep folks posted on what our next steps are, what that means. I'm going to try to take a link. I look at the chat, I see it kind of going crazy. Nadine, I love that idea, the mutual aid idea. I would love to revisit that. Thank you, Brian, for dropping the link in the chat. I will also drop the direct link for folks who want to register. Kat, I see. Yes, Yoshi, the 421 vote difference. Yes, that is what got Chief Justice Newby elected. Yes. Kat, I see a few questions about folks who have already registered. Gino, let us know if we need to table those for
We'll
later.
get to that at the end. Mhm.
Okay, awesome. So yeah, I think that's all that I have to add. At this point, we are leaning in the narrative. We are leaning in telling our stories and not letting our voices be silenced. And we hope that you all will come out and join us tomorrow.
Thank you so much, Brittany and Kat. And I want y'all to give some love in the chat and your reactions for the Forward Justice and the Southern Coalition for Social Justice teams who have been litigating these cases in court for years. And if you are in the chat and you are for second chances, you are against what this court is in lockstep with legislature, let us know in the chat. Let us know how you think about this. Let us know if you think this is right or wrong, and put it in the chat so that everyone can see it. Because we are here tonight not only to educate, but to rally and mobilize, which is why we are going to be in Raleigh tomorrow, standing up for people all across the state who are lobbying for second chances here in North Carolina. With that, I want to take it over to another veteran of our movement here, Saylor Jones, Associate Director at Common Cause North Carolina, to take us on a little bit of a history lesson so that we know where we go from here. So let's go to the next slide, and Saylor, please come on.
Thank you, my friend Gino. And it's hard to follow Brittany Cheatham. I won't even hardly ever try, but Brittany brought up an amazing point, my friend. The razor thin margins in North Carolina for vote counts. If you cast your memory back there, Lord, to 2008 and think about Barack Obama winning the state of North Carolina, that was about 14,000 votes. When you think about Roy Cooper winning in 2016, that was about 10,000 votes. Again, a Chief Justice can take hold of the Supreme Court with just several hundred votes. Those vote differences combined don't equal the 56,000 people disenfranchised by the new Chief Justice. So I just want to make it perfectly clear, in the great state of North Carolina, these votes matter. Every vote matters. And to have them taken away, to have such a historic ruling gutted, like all three of these rulings were, is a travesty. And friends, these three dangerous rulings, make no mistake, they were a calculated political coup on a Friday afternoon that immediately, as Jeff Loperfido will say, set the state and its voters up for failure. They also make perfectly clear, my friends, that this year, North Carolina, and make no mistake, funders, if you are out there tonight, will once again be the nation's epicenter in the fight for a just democracy. That's all of us, friends. And for anyone who has been in this state for the past decade, that means everything old is new again in the great state of North Carolina. Largely the same legislative leadership installed right now also brought us the nation's worst attack on voting rights 10 years ago in the so-called monster voting law, a sort of Frankenstein's monster stitched together from all the worst election laws found across this country, from the strictest voter ID law to slashing popular early voting options. And to make sure back then that their laws went unchallenged, lawmakers paired it with a repeal of judicial public financing, allowing all this big money to rush in to influence our impartial courts. And we are now seeing that wrought today. The decade's attack on judicial independence continued throughout 2010 all the way up to 2022, and lawmakers worked to change judges who could challenge their laws at every turn. They even turned the election of trial judges into partisan races, making North Carolina the first state, friends, not only in flight, but in 100 years to return to a widely panned policy of partisan judicial elections. These are the same lawmakers back then who attacked and extended to legislative efforts to erode the governor's office, the attorney general, even the state board of elections. And so you may even remember 5 years ago when they rammed through a state constitutional amendment for voter ID using confusing language to advance their effort, get a blank check to define who could and could not vote. Well, it's back again, my friends. And only a few years after that, many of these same lawmakers tried to make it harder to vote during a global pandemic. So why am I reminding you of all this right now? Why am I being the Debbie Downer of this great group of people? Well, I've been in this fight a while, friends. And I want to make it perfectly clear that this year's fight in 2023 is different and it is bigger. In 2023, a full decade out from that initial monster voting law, we're seeing a resurrection, a zombie law of all these attacks, from constitutional amendments to cuts to early voting to attacks on the governor's power. We got it all this year. And even our power to protest these dangerous laws has been put under attack. So while North Carolinians are no strangers to distorted districts and voter suppression, and even attacks on our most vulnerable communities ahead of high-profile presidential elections, we now have a judiciary and a legislature in lockstep in advance of what we're calling a long train of abuses, my friends, meant to steamroll a multiracial democracy in the great state of North Carolina. So to be clear, they're primed to debate once again, altering our state's founding document through another round of vague constitutional amendments. Again, multiple constitutional amendments have been proposed, including ones that would cut early voting. There's a concerted effort afoot at the legislature to silence young voters, with our politicians partnering with election deniers to make it happen. They've already prepared to unapologetically install barriers to voting, gut popular election safeguards like same-day registration and the absentee voting grace period that helps you out when the USPS can't. They want to disenfranchise tens of thousands of justice-involved voters, like we talked about, and now even pack and crack your voting districts at will. They're going to try to implement this voter ID law, as Jeff talked about, in a few months' time, when they couldn't successfully do it in a few years' time, and slash funding to the State Board of Elections as they go to make it even harder to educate the people we know that the voter ID law is even in place. And they're going to continue to try to steal power from the executive branch while they try to further corrupt the judicial one. So make no mistake, friends, this year is the culmination of a 10-year plan by a few politicians to delegitimize the courts and erode the power of other branches of government while they do it. But now it packs a decade of attacks, from confusing amendments to unjust constitutional maps, all into 1 year, friends. All the fights we have seen over the past decade, they are being compressed into this 1 year. And who will stop them, friends? Well, our answer, friends, is you. This isn't the first time that our branches of government have been undermined and have been undermining the will of the people and the basic tenets of our democracy. But we also know the people united can never be defeated. And when lawmakers have done this before, when they've used a special session, for example, that was supposed to be about hurricane relief to try to pack the courts, when lawmakers attempted to gerrymander our judicial districts, when lawmakers refused to provide ample time for us to provide public comment, and we demanded them to show us the maps when they tried to gerrymander us out of our districts, you showed up. You banged on the doors. You showed up en masse to fight back. You showed up at the polls like never before. You showed up at public hearings to demand transparency and accountability. We are asking you tonight, friends, to do it all over again. It's time to once again unite in C, because as Bishop Dr. Reverend Barber said today, we need an all hands on deck approach to respond to this particular crisis, friends. It will be up to us to once again inspire and mobilize all people, creating a fourth branch of government where the other two have gone, that will kick off a long-term plan for reform, for resistance, and even a people's revolution, friends, in the years ahead. It's designed to educate people about what's happening, that there's going to be a voter ID law, that their districts are going to change. It's also going to be about demanding better from our representatives as we go, to make sure they do more and better for us, and we demand it. And we're going to show up everywhere we can, from public hearings to polling places, to make our voices heard like our rights depend on it. They certainly do, my friends. So to share more about how we're educating people, our neighbors, and demanding more and better from our representatives, I'm thrilled to pieces to turn it over to our brand new Triangle Campus organizer who just started today, Jasmine Abney. Jasmine?
Good afternoon or good evening, everyone. I am Jasmine Abney. I'm a soon-to-be alumna of North Carolina Central University. And like the wonderful Sailor just let you all know, I'm just starting or returning to Common Cause North Carolina, as I've served as a fellow during my time as a student. And I'm just so excited to be here. That fourth branch, the people, public interest, the press. It starts tonight. Educating our networks, everyone you know, I'm literally going to call my grandma about it, demanding transparency and accountability from our so-called leaders. Make it clear to your friends and family what happened just last week. This is a direct assault on our democracy and the power of the people. Voters are supposed to choose political leaders, not the other way around. But with this ruling, Republicans in the North Carolina General Assembly will be able to further their extreme partisan gerrymandering and attempt to silence the voices of many, especially Black and Brown voters. Instead of working towards a better North Carolina for us all, Republican politicians are continuing their crusade against Black, Brown, and young voters. Just a few months ago, this very court declared the onerous voter ID law as unconstitutional and tainted with racial bias. Now that Republicans control the court, they are doubling down on this shameful law in an attempt to weaken our multiracial democracy. Republican politicians know their policies are cruel and unpopular, so they're resorting to this kind of unconstitutional, undemocratic, and frankly embarrassing display of partisanship. If Republicans had the support of the people, they would not need to ignore the Constitution and undermine our democracy to stay in power. These rulings are part of a long-term strategy by Republican politicians to disenfranchise Black voters. Courts have repeatedly ruled that voter ID laws and felony disenfranchisement discriminate against Black residents, and yet Republicans continue to pursue them. Not only that, the North Carolina General Assembly has already cracked down on free speech and the right to protest with the passage of House Bill 40 just earlier this year. The people of North Carolina deserve an impartial and honest judiciary. Instead, the state Supreme Court has destroyed their reputation and the voters' faith in democracy, all to feed power-hungry Republicans in the state legislature. Tonight, let us commit to fight to making voting more accessible. So let me know in the chat if you like to vote and you want your friends to vote with you and you want us to keep that right. Our state is strongest when everyone has a say in decisions that make our lives, and every North Carolinian deserves to fairly choose their elected leaders. I'm going to turn it back over to Gino.
Jasmine, you are a superstar. Let's give some love. Jasmine just came in today, started today to give us this good word. Thank you for being here, my friend. So We're here to unite North Carolina. We're here to build, continue building on that legacy of a fusion movement here. And we know that Friday was a gut punch in addition to gutting some huge victories that we had won in this state. But it's not the time to give in. It is not the time to cave in. It is not the time to admit defeat. We've got a whole lot of people that we've got to educate, who we've got to tell about this. We had over 200 people on this call tonight, over 300 who were registered. We got 10 million some people here in North Carolina. I see Team APRI there in the chat, and I know no one knows better how to register and educate voters than them. I know no one knows how to engage with communities like Forward Justice, like their Freedom Summer last year and the Freedom Summer Coalition. I know the same of the League of Conservation Voters. I know the same of each and every single one of you. So we are here to learn about these cases. And that's right, Luther, it's time to go. So what are we doing next? First, you've got a lot of links in the chat. If you've been sharing links in the chat, I want you to put them back in. But if you are interested in working with Common Cause North Carolina for the latest events, actions, and resources, and to stay on top of it with us, and you aren't already, join us at ccnc.me/action team. That includes you on the list for everything that's coming up, and share it with your friends as well. And that's going to be important because we want to be able to tell you like things about like the, oh God, why am I losing my words here? We want to be able to tell you about things like the lobby day tomorrow with the Second Chance Alliance, but also with our friends at the Budget and Tax Center about the state budget, our dollars, our future, and additionally, our friends at North Carolina Asian Americans Together, who are hosting their own lobby day as well. We got 3 big groups coming to Raleigh tomorrow. I know we're going to stop traffic. I know we're going to be in that building raising hell, so we want you there with us. Join the lobby days, come down to Raleigh with us if you can, but we are not stopping in Raleigh. We are not going to make you drive 3 or 4 hours all the time, I promise. Oh God, I didn't want to see that photo. We're not going to make you drive 3 or 4 hours, because what Common Cause North Carolina is going to do, and with anyone who wants to join us, starting this summer, we are going to be going around the state to spread the good word of what you heard tonight to every corner of this state, from our friends in Halifax County to our friends in New Hanover. President Maxwell, get ready, we're coming. To our friends in Burke County, Miss Kincaid, I saw you were here tonight. We are going to be coming all around the state to talk about what we talked about here and make sure everyone has what they need to be able to vote here in North Carolina. One of the places we're going to be starting is in the Sandhills, and I want to invite one of our latest and newest organizer who's based in Cumberland County, Lisette Rodriguez. Come on, give us a quick little plug about if you are in the Sandhills region, what's coming up there. So Lisette, come on through.
Hi everyone, my name is Lisette. I'm the Outreach and Engagement Organizer for the Sandhills area, but I'm based in Fayetteville, North Carolina. And yeah, we're going to be holding our first Sandhills supporter call on May 9th at 7 p.m. on Zoom. And we're specifically targeting folks who live in the Sandhills area. So some of those counties include Cumberland, Hoke, Harnett, Moore, Sampson, or Robeson County. So if you guys are interested, we're going to drop a link in the chat where you can register for our Zoom. And yeah, we're looking to build out the Common Cause base here in those counties that I just mentioned and increase voter support out. And we're really excited for you guys to connect with us and get boots on the ground.
Thank you, Lisette. Lisette, put your email in the chat so the good folks in the Sandhills, like a Helen Probst Mills, can get the chance to meet you and join in that event to come. And that is the play here, friends. We are going to be not only educating our electorate and educating our base, but expanding the electorate and making sure that everyone who we know has something to say at the polls, everyone who wants to vote for second chances, everyone who wants to vote and protest of a voter ID and partisan gerrymandering can get to the polls and be part of this movement. So expanding our movement, expanding past just what, as Reverend Barber also said in his piece today, that democracy and the fight for a just democracy for all is not just a special interest, it is an all hands on deck situation. And as we educate our base and we expand the electorate, you know, just like Forward Justice is leading tomorrow, just like the Second Chance Alliance is leading tomorrow, we're going to be showing up and being real loud, and we're going to impose a lot of pain on lawmakers who impose pain on us with their power gone wild. Finally, we want to make sure you share the resources. You will get an email this week and emails from us to come, especially if you sign up at the Action Team link for a toolkit on how to talk about these cases and how to share it with your network, as well as the voter education and voter ID phone banks and door knocking and relational organizing that is to come. Finally, it does take a lot of resources to do this work. We want to bring on more organizers in all parts of the state, just like Lisette, just like Jasmine, and reach parts of the state that maybe we haven't invested in so much before, and we will need everybody now. So if you are interested in donating to Common Cause or any of the organizations you see here, you can, for Common Cause, go to ccnc.me/donate. And I encourage our friends here as well. And April, please put your contact information in the chat as well so people know to reach you. But do the same for our fellow organizations and do the same for organizations in your neck of the woods as well so we can continue this fight. Now with that, it is close to the end of our time. We might keep you a few minutes longer. Please feel free to stay as long as you want. But we've got a lot of good questions that came in the chat. So Ann Webb, I'm going to ask you to come on here with us. I'm going to add you as a pin and let us know the questions that come, and we'll steer it to the panel of experts that we've got here. So come on through, Ann. What's the first question we've got?
Hey, folks. So, Ted, I see your question. You have not been forgotten. There is a question here about where the litigation stands and what this means going forward. So I wanted to hit Hillary up with, in particular, this question about what it means that these cases were overturned with prejudice. To me, it seems that similar claims cannot be brought again before the North Carolina courts. What are potential plans for moving forward?
And thank you so much for that question. It is difficult that the court has dismissed these cases with prejudice. It does not stop us from a couple things, though. It does not stop us from continuing to think critically and creatively about the way forward as far as legal claims. It does not stop all of the political accountability that everyone has talked about tonight and the organizing that will require. And then I encourage you to follow those links and do that. And it does not preclude congressional action. I think there was another question that I saw in the chat about, is there federal congressional bill on this? There actually is. Last session, the Freedom to Vote Act, which was proposed by Amy Klobuchar, and does have specific criteria for redistricting congressional maps that would prohibit partisan gerrymandering. So that's just one example, and there's a lot of great parts of that bill that would also help other aspects of our democracy be strengthened. So there is a way forward. It's going to take creative thinking and work. And thank you for the question.
Thank you.
Thanks, Ann.
Oh, thank you, Hillary. So Hillary, I want to hit you with one more that that Robin Sanders actually helped answer a little bit, but just while we're on the subject of litigation, a lot of folks are familiar with the Moore v. Harper case, which is sitting before the U.S. Supreme Court. I wonder if you could share a few thoughts about whether anything has changed with that case as a result of these rulings.
If you read the decision from Friday closely, you do not see an explicit overturning of the court's prior determination that state courts and state constitutions can weigh in on congressional maps. They have a role to play. That was the decision that was held in February 2022 that's being appealed before the Supreme Court. So we put in briefing in March when the rehearings were granted that we believed the court still had jurisdiction and should unambiguously reject the radical independent state legislature theory that's at issue in that case, Moore v. Harper. And as I sit here today, I think we're still digesting the opinion. I think that determination is unchanged. The court should avail itself of this opportunity to unambiguously reject the independent state legislature theory, and it should hold that state courts and state constitutions, even if they don't act the way we would have them, they still have an important role to play in protecting voters.
Thank you so much, Hillary. One more question for you while you're in the hot seat. Is a racial gerrymander challenge permissible as it relates to the next set of maps that we see?
Yes, all of those other federal claims are absolutely still available. you have to be able to make those claims. And of course, what we've seen is a period of adaptation. The adaptation, pardon me, the legislature has adapted how it is gerrymandering. And last cycle, it was racial gerrymandering. This cycle was partisan gerrymandering. And we just have to stay vigilant with creative ways of boxing them in and challenging them. And to Tyler's point, they could create fair maps. They are fully capable of doing that this summer. And if they decide to do the people's business, that's what they'll do.
Thank you, Hillary. I wanted to turn it quickly over to Tyler and also, to Tyler, just to share briefly about the gold standard independent redistricting commission bill that folks are working on here in North Carolina. There was a question about both whether we could have a state constitutional amendment that could implement nonpartisan redistricting, as well as whether there's any credible legislation in process. So I wonder if you could just share kind of a very brief summary of what we have.
Sure. So Senate Bill 642 has been introduced. It's an independent commission bill, and it would take the power out of the hands of the legislators. So there would be an independent commission made up of citizens, 5 Republicans, 5 Democrats, 5 unaffiliated voters who would draw the maps, and they would have to follow very strict criteria. They wouldn't be able to draw districts for partisan gain. In fact, the districts that they do draw would have to be evaluated to make sure that they don't even inadvertently draw partisan districts. They would have to respect communities of interest. And there's also several requirements in that bill that state that there would have to be 20 public hearings, 10 before the maps were drawn, 10 after the maps were drawn. So it's a very comprehensive bill, and it would be a much better process than what we have now, essentially putting it in the hands of citizens who would have to follow a strict process rather than what we have now, which is legislators, really legislative leaders, doing what they want. So a much better process. And again, that's Senate Bill 642. And I would highly say, if you can contact your legislators and let them know that you want to see that bill move.
Thank you, Tyler. So Kat, I wanted to put you in the hot seat for a moment with a couple of questions. One is related to voter ID. And the question is there a live federal case against implementing voter ID? And what's the status?
There is. We do have a challenge in the Middle District of North Carolina, which was brought against SB 824, alleging that it is racially discriminatory. That case was originally set to go to trial and then was postponed just because of the other pending cases. So there is a live case, although just to be clear, as Jeff said, his case was the one that had an injunction in place. So with, the current state right now today is that they will begin implementing voter ID unless and until there's a new ruling in our federal case. So there is a live case, but there is not a live injunction in that case. And then also I think there's been some mention of our constitutional amendment case. We have a case that where we challenge just the right of a legislature that has been found to be gerrymandered by the US Supreme Court to then use that gerrymander to amend the Constitution. We got a great ruling from the North Carolina Supreme Court saying, yes, there are limits on what you can do when you are a gerrymandered legislature, what you can do with that power. That case has now gotten remanded just for some more fact finding about what they did in this particular case with both the voter ID amendment and the tax cap amendment. So there are still 2 live cases relating to voter ID right now.
Thank you, Kat. That's really helpful. So another question for you is, who is going to notify people who are no longer permitted to be registered voters about their status? I'm going to read this question word for word because someone had a really good specific question. If someone is on supervision and registered and voted this past year, what if they go vote in the next election, not realizing, are they in jeopardy of being arrested or charged with a crime if they were previously registered?
Those are great questions. For the first one, I'm just going to read what the state board said, because they are, of course, the ones who are implementing this. They came out with a press release and they said that the state board will receive lists of people currently serving felony sentences from the Department of Correction and the Department of Justice, and will forward them to county boards to cancel the registrations of anyone who's ineligible. I don't believe that in that press release they talked about notification, that they explicitly said they would be sending a letter. So as always, we are working for people who are justice involved, and we'll be working to make sure that we get more information on how that's going to work. To the second question, and Jeff can feel free to jump in also, because there is a challenge to the statute that makes this a crime. To give some context, there's a law in North Carolina that if you vote while you were ineligible, because say you just thought that your post-release supervision was done and you were wrong, you can be charged with a crime. It does not require that you knew. It doesn't require intent. And that is also something that is up in the legislature right now. If someone knows the number of the bill, that would be great. But there is a bill right now that you can ask to be supported that would essentially say, can you please take out the intent, this requirement, there's no intent to actually show that someone knew they weren't eligible. Because it seems fundamentally unfair that you would just, by a mistake of how complicated our criminal justice system is, vote thinking in good conscience that you were done with your supervision, that you would then be held accountable for that. But I'll also let Jeff add if there's anything else about sort of the statute that makes it a crime.
No, I think you hit it all, Kat. I mean, it's a pretty extreme penalty too. It's one of the there's only a handful of felonies in the election code, and that's one of them, and it's one of the few where there's no intent requirement at all. So you can very easily fall into that prosecution. And then we've also seen that it's basically, depending where you live, dictates whether or not you're going to be prosecuted, because many district attorneys are like, well, this seems bogus, we're not going to prosecute you for this crime, it doesn't have an intent requirement. And then others who feel it is politically advantageous, like the then district attorney in Alamance County, who's now a sitting judge in Alamance County, have made prosecutions a point of emphasis for their VA runs. So yeah, something we're hoping to get off the books either through litigation or legislation one of these days.
Yeah, so I think the answer to the question, if I understood it correctly, was yes, that someone could, if they voted again and they are still on supervision, if they did it, just by accident, they didn't hear about this ruling today, last week, they could be eligible to be charged with a crime for that. So like Jeff said, I think one thing that people can do right away too is just ask for that bill to be passed so that we can at least make one small step in making things better in this really unfair scheme that they have.
I think I'm going to pass it back to Gino now. I think we've covered all the questions that I've seen, except Gino has asked to answer one in particular from Stuart, which is an excellent question and a great way to wrap up. And just wanted to flag while Gino's responding there, if I missed anything and anyone has a question, please drop it in the Q&A or the chat right now, because we're about to wrap up. And if you didn't get your question answered, Gino will be emailing everyone after the call, and you can submit it there, and we'll make sure that you get an answer from one of our expert panel.
That's right. And we will be saving the chat tonight. We will be saving the questions that you've answered. We'll be developing it into an FAQ and other resources, and we'll make sure you get all of the information that you need. I think part of this now, we have been asked, how are we going to overcome this? We've got this General Assembly in power. We know the courts are in lockstep with the legislature, and it just means we have to have a 10-year plus vision. We are in the work now to educate the electorate, to keep our people safe in the context of what Kat and Jeff were just telling you about how people could be charged with crimes. We're also in the movement to expand the electorate. I see the New Rural Project here. I know friends from Down Home are here. I know friends from APRI in here. It may seem like in many parts of the state that it is worth abandoning those places. And I know that many of you here know that that is not the case. From Halifax County to Pasquotank County to Bladen County and all the way out there in Catawba and Haywood and Jackson County, there is a political pro-democracy majority all throughout this state. It happens every single day. You all are a part of it every single day. And our work now is to do not just the mobilization, but in the words of our good friend, Ms. Cheryl Carter at Democracy North Carolina, to be organizing and to be in it with us. If you want to be with Common Cause, or you want to be a Forward Justice, or you just want the resources to do it yourself at the neighborhood level, our work now is to organize, because in 2024, we've got a governor's race at the top of the ticket. We've got General Assembly seats, every single one that's going to be up for election. There's going to be a statewide state Supreme Court race that is on the ballot. And moving forward, we know that the U.S. Senate will be in 2026, that there's a presidential race in 2024, and that we've got more judicial races to come ahead in 2028. So we are here right now to unite North Carolina around what has maybe been one of the darkest moments for our democracy in a very long time, but one that we have met before, we have risen to the challenge before, and whether it was a fusion coalition in the 1890s or a fusion coalition in 2013 or a fusion coalition in 2023, we're going to meet this moment now, and we are happy to have you here with us to begin that response and look ahead to 2024. So the strategy is to expand the electorate, y'all, and organize everywhere. With that, I want to thank you for being here tonight. I want you to share some love in the chat before you go that you are here to unite North Carolina. You have our emails as well. Promise if you registered for tonight, you'll get a recording, you'll get the slides, you'll get the script, you'll get all the good stuff. You will be overwhelmed. You'll say, Gino, never email me again. And you may just have to hear from me one more time. So thank you for being here. Thank you for being a part of this. And we'll make sure to answer all your questions as we learn more in the days ahead. But have a good night. Drink some water, eat some food, and we'll see you soon.